Imagine being 7 months pregnant and suddenly receiving a termination letter from your employer. You're confused, stressed, and unsure of your rights. Is that even legal? This isn't a rare scenario. In fact, you might have seen headlines where pregnant employees were asked to leave, some subtly, others openly. There is a dangerous myth floating around that pregnancy makes an employee less efficient or a burden. But here is the truth: the law stands firmly to protect women during one of the most vulnerable and powerful phases of their life, motherhood. That is where the Maternity Benefit Act 1961 comes in. Whether you're a law student preparing for exams, a working woman who needs to know her rights, or an HR professional responsible for legal compliance, this act is something you must understand. This isn't just legislation, it is a shield ensuring women get paid maternity leave, protection against dismissal, and the dignity they deserve. Stay till the end, we'll solve 5 MCQs that might come in your exam or interview. To truly understand the Maternity Benefit Act, we need to go back in time to a period where there were no formal protections for women, working women, during pregnancy. In colonial India, women working in factories, plantations, and mines were often forced to continue working till the last stages of pregnancy, with no pay, no medical aid, or no job security. Many lost their jobs simply because they became mothers. The need for dignified working conditions for women gained momentum with the rise of labor movements and global attention on maternal health. In fact, India is a founding member of International Labour Organization (ILO), which laid down early conventions on maternity protection as far as 1919. It was 1961 that the Indian Parliament passed the Maternity Benefit Act, aimed at regulating the employment of women before and after childbirth and providing for maternity leave, benefits, and job security. The need for the law has evolved too, with key amendments in 2019 extending paid leave from 12 to 26 weeks for eligible women, introducing work from home options, and requiring companies with 50 plus employees to provide creche facilities. This act is not just a welfare measure, it is a constitutional commitment under Article 42, which directs the state to make provisions for securing just and humane conditions of work and maternity relief. So, the Maternity Benefit Act isn't just about leave, it's about respect, safety, and equal opportunity for working women. Next, we'll see about the key provisions of the Maternity Benefit Act 1961. First, we have eligibility. First things first, who can actually claim maternity benefits? Under the Act, a woman must have worked for at least 80 days in the 12 months preceding the date of her expected delivery in the establishment where she is claiming the benefit. Let's say Aarti joined a private company and completed just 75 days of work when she became pregnant. Unfortunately, she wouldn't be eligible, but if she worked for 81 days or more, she qualifies for all the rights under the Act. And yes, this applies not just to full-time employees, but also to women working in factories, mines, plantations, shops, and even some government sectors. Duration of maternity leave. Now comes the core of the Act, the leave itself. A woman is entitled to 26 weeks of paid maternity leave if it is her first or second child. Out of this, up to 8 weeks can be taken before the expected date of delivery, and the remaining can be availed after childbirth. But if it is her third child or beyond, the entitlement drops to 12 weeks, still significant but with a reduced benefit window. Think of it this way: if Priya is expecting her first baby in June, she can start her leave from early April, take 8 weeks before birth, and then continue for another 18 weeks post-delivery. That is 6 months of job-protected paid leave. And remember, this leave is fully paid. The employer is bound by law to make her average daily wages. Surrogacy and adoption. The Act also recognizes modern family structures. If a woman adopts a child under the age of 3 months or becomes a commissioning mother through surrogacy, she is entitled to 12 weeks of maternity leave, starting from the date of child is handed over. For example, if Meera adopts a newborn girl from a registered agency, her 12-week leave starts the day she legally takes custody. The law ensures bonding time irrespective of biological children. Work from home options. Post maternity, balancing motherhood and work isn't easy, and the Act acknowledges this too. After availing maternity leave, a woman may request to work from home, but this is a subject to the nature of her work and mutual agreement with the employer. It's not mandatory for the employer to allow it, but if the role is suitable, say content writing, legal drafting, or coding, it becomes a viable option. Let's say Neha is a legal researcher. After her maternity leave, she can propose a work from home arrangement with agreed timelines and deliverables. Prohibition of dismissal. Here is a powerful safeguard. No woman can be dismissed from service while she is on maternity leave. In fact, even altering her terms of employment, like cutting salary, shifting roles, or transferring her without consent, is illegal during this period. Imagine being in your third trimester and suddenly receiving a termination letter. The law strongly prohibits such practices. And if an employer violates this, they face penalties and even imprisonment. Also, if a woman is dismissed during pregnancy without reason, she is eligible to receive the maternity benefits. Creche facilities. Another important and often overlooked provision, creche facilities. Every establishment employing 50 or more employees must provide a creche within a prescribed distance. This allows working mothers to safely leave their children while attending office. Moreover, a woman is allowed to visit the creche 4 times a day, including her rest intervals. This ensures continued mother-child interaction and reduces anxiety for new moms at work. For instance, if Ananya works in a tech park with over 50 employees, her company must provide access to a creche nearby, either in-house or via a tie-up. Medical bonus. Lastly, the law provides for a medical bonus, currently notified as Rs 3,500. This is payable when the employer does not provide a prenatal or postnatal care to the woman. In such cases, the bonus compensates for the health care she arranges privately. It is a recognition that maternal health care is non-negotiable, and when the employer falls short, the law steps in. And remember, this amount is in addition to her paid leave. As you can see, the Maternity Benefit Act is not just a legal formality. It is a protective shield for working mothers, ensuring their health, dignity, and employment rights are perceived. Stay with us because up next, we'll test your understanding with real-life challenges and 5 MCQs that might just appear in your next law exam or job interview. Let's step into reality for a moment. Imagine a woman working in a private school. She informs her employer about her pregnancy, and suddenly her workload doubles. No formal leave is granted, no creche facility, and slowly she is pushed to resign. Sadly, this isn't rare. Despite laws being in place, implementation remains patchy, especially in some or unorganized sectors. Many women aren't even aware of their rights under the Maternity Benefit Act. HR professionals and managers play a key role here. They must ensure workplace policies align with the law, because non-compliance isn't just unethical, it is illegal. Now, let's go a step deeper. The Indian Constitution under Article 42 directs the state to make provisions for maternity relief. So, the Act is not just a statute. It is an expression of gender justice and human dignity. And yet, many women fear asking for their rights, thinking it might cost them their job, promotion, or professional respect. Here is a scenario. A woman resumes work after 26 weeks, but the employer refuses to assign her core responsibilities, saying, "You have been away too long." That is discrimination, plain and simple. The law doesn't just cover leave, it protects the conditions of service too. Let's remember, maternity benefits aren't a favor. They are a right, essential for health, equality, and justice. Now, let's a quick question to you watching this. Have you or someone you know faced such issues during or after maternity leave? Drop it in the comments. Let's open up this conversation. MCQ 1. What is the minimum number of days a woman must have worked in an establishment to be eligible for maternity benefits under the Maternity Benefits Act? 120 days, 80 days, 60 days, 100 days. The correct answer is B, 80 days. As per Section 5, Clause 2 of the Act, the woman must have worked for at least 80 days in the 12 months preceding the expected date of delivery to be eligible for maternity benefits. Always remember, 80 days is the golden number for eligibility. MCQ 2, how many weeks of paid maternity leave is a woman entitled to for her third child? The correct answer is 12 weeks. The Act provides 26 weeks of leave for the first two children. From the third child onward, the entitlement reduces to 12 weeks. 8 weeks pre-delivery, 4 weeks post-delivery. We can break that down like that. This change encourages population regulation while still ensuring protection. MCQ 3. A commissioning mother under surrogacy is entitled to how many weeks of maternity leave? The correct answer is 12 weeks. The 2017 amendment introduced benefits for adoptive and commissioning mothers. They are entitled to 12 weeks of maternity leave starting from the day the child is handed over. Commissioning mother is a biological mother who uses surrogacy. MCQ 4. Under which article of the Indian Constitution does the state have a directive to provide maternity relief? Article 14, Article 15, Article 21 or Article 42? The correct answer is Article 42. Article 42 of the Directive Principles of State Policy mandates the Act to ensure just and humane conditions of work and maternity relief. Though not enforceable by courts, it forms the constitutional backbone of the Maternity Benefit Act. MCQ 5. Which of the following is true about creche facility under the Act? A. It is optional for all employees. It is mandatory only in government offices. It is compulsory if an establishment has more than 50 employees, or it is applicable only if there are more than 50 women employees. The correct answer is C. It is compulsory if an establishment has more than 50 employees. As per Section 2017 amendment, every establishment with 50 or more employees, not just women, must provide a creche facility. The mother can visit the creche 4 times a day, including the rest intervals. MCQs in exams are not just about the answer. They often test your grasp of exceptions, figures, and constitutional links. So revise these smartly and stay sharp. Want more MCQs on labor law or corporate governance? Let me know in the comments. The Maternity Benefit Act ensures that, so we'll see here a 1-minute summary of the Benefit Act. The Maternity Benefit Act ensures that no woman is forced to choose between her job and motherhood. If she has worked at least 80 days in the past year, she is entitled to 26 weeks of paid leave for her first 2 children and 12 weeks for subsequent ones. Mothers adopting or using surrogacy get 12 weeks too. The Act strictly prohibits dismissal during maternity leave and mandates a creche facility if the workplace has over 50 employees. Optional work from home provisions can be arranged. Rupees 3,500 medical bonus is granted if the employer doesn't provide pre or post-natal care. We also tackled 5 exam-focused MCQs and discussed real-life workplace challenges, connecting it all to gender justice and Article 42 of the Constitution. Now you know the law. Time to use it for yourself or someone who needs it. So that wraps up our deep dive into the Maternity Benefit Act, from understanding your rights and leave duration to knowing how adoption, surrogacy, and even creche access are covered under this empowering legislation. But here's the real takeaway. Laws only work when people know and use them. Whether you're a student, an HR professional, or someone in the workplace, understanding this act is essential, not just for women, but for everyone supporting gender equity at work. To all the women watching, your rights are protected by law. Don't hesitate to speak up or seek support. To students preparing for exams, I hope the MCQ and real-world scenarios helped connect theory to practice. To employers and HR teams, this is a reminder that compliance isn't optional. Supporting motherhood is part of workplace dignity and constitutional duty. Remember Article 42. Now it's your turn. Have you or someone you know faced challenges in claiming maternity benefits? Was your workplace supportive, or did you face any legal or social hurdles? Drop a comment below. Let's open up this conversation. If this video helped you, like it, share it with your friends or colleagues, and don't forget to subscribe for more content on law, justice and rights, made simple and relatable. Thanks for staying till the end, and remember, law is power only when you know it.